5 days later, Mr. Blanche was forced to acknowledge that that was a false statement. In fact, it was in a document filed by the Department of Justice where he said it is true, he went on TV and said it is true that over the years they have selectively shared information with law enforcement. That's well documented and no dispute, but they aren't charged with any of that conduct. What the hell does that mean, they aren't charged with any of that conduct? The entire premise of this fraud scheme is that SPLC was actually using the money given by the donors to support the hate groups, not to dismantle them as they represented. So any knowledge by the government that the SPLC shared information with them to dismantle these groups completely undermines and defeats the fraud claim.
What happens when a congressional hearing turns into a full-blown legal takedown? Dan Goldman just brought the receipts, and what he revealed about the DOJ's SPLC indictment has sparked serious questions about credibility, consistency, and political motive.
Thank you, Mr. Chairman. So the hate map, you don't like it. I get it. But the SPLC is not a government organization, and we have the First Amendment. So they're free to put what they want, and you, all of you, are free to speak out against it and to explain why they're wrong. But as I think of my Republican colleagues, we believe in the First Amendment, except, I guess, when it's critical of far-right groups or conservative groups who support these Republicans. But you are not free to use the government to criminally indict an organization based on a completely bogus charge. And I want to dig into this indictment. On April 21st, hours after Acting Attorney General Todd Blanche and the FBI Director Kash Patel announced this indictment, Mr. Blanche went on Fox and said this.
No information that we have that suggests that the money that they were paying to these informants and these members of these organizations, they then turned around and shared what they learned with law enforcement. To the contrary, or else we would have known from their own words that they had given this money to these guys, and we didn't know it.
So they had no idea that the SPLC was using informants and providing information to the government. 5 days later, Mr. Blanche was forced to acknowledge that that was a false statement. In fact, it was in a document filed by the Department of Justice where he said it is true, he went on TV and said it is true that over the years they have selectively shared information with law enforcement. That's well documented and no dispute, but they aren't charged with any of that conduct. What the hell does that mean, they aren't charged with any of that conduct? The entire premise of this fraud scheme is that SPLC was actually using the money given by the donors to support the hate groups, not to dismantle them as they represented. So any knowledge by the government that the SPLC shared information with them to dismantle these groups completely undermines and defeats the fraud claim. But there's plenty of evidence that the FBI knew that the information provided to them by the SPLC to help the FBI dismantle these groups came from informants. In fact, 2 weeks before the indictment, the SPLC presented the U.S. Attorney's Office with evidence that showed that they had been sharing information from informants with the FBI dating back to 2018. And even Blanche's statement that none of the information shared with the FBI was charged in the indictment is false. It doesn't matter because that's not what the fraud claim is, but it is false because the Charlottesville Unite the Right movement is specifically mentioned in the indictment. But the indictment does not mention the 45-page report that the SPLC sent to multiple FBI offices before the Unite the Right event that included information from their informants. Now, we've established that. Now we know this fraud claim is completely bogus. But it gets worse because it's not even part of the allegations. In paragraph 19 of the indictment, it explains the fraud scheme. It says that the SPLC represented to the victim donors that their money would be used to help dismantle violent extremist groups, but that they did not tell those donors exactly how they would do that. So it actually charges fraud by omission, not misrepresentation. But in order to have fraud by omission, you must prove that the omission was material to the victims such that they would have acted differently if they had known about it. But there isn't a single allegation in the indictment that any donor would not have donated if they knew about the payments to informants. In fact, everything we know is the opposite. Ms. Wiley has pointed out repeatedly about how donors are trying to continue to give. And that Intercept article that Ranking Member Raskin introduced cites 20 donors who now say that they either knew about the paid informants or they would have made their donations anyway. And so what is this really about? It is weaponizing and politicizing the Department of Justice, not any of your groups, to quash and squash free speech, to muzzle people that because you are trying to protect far-right investigations who are huge supporters of the Republican Party. They may not do any oversight over this indictment, but I guarantee you when we take the majority back in January, we will be doing that oversight and they will be held accountable. I yield back.
A heated congressional hearing erupted as lawmakers clashed over the controversial indictment involving the Southern Poverty Law Center, SPLC. Representative Dan Goldman opened fire on the credibility of the case, questioning whether the Department of Justice was stretching legal theories to fit a political narrative. His central argument was direct: if the foundation of the indictment is flawed, then the entire case collapses under its own weight. Goldman zeroed in on statements made by Todd Blanche, pointing to what he described as conflicting public remarks and internal DOJ positions. According to Goldman, Blanche's earlier claims on media platforms appeared to contradict later acknowledgments in official filings. That inconsistency became the backbone of Goldman's argument that the prosecution theory may not be as solid as presented. A major point of contention was the allegation of fraud involving SPLC donor intent. Goldman argued that the indictment relies heavily on fraud by omission, a legal theory requiring proof that donors would have changed their behavior if they had known additional details. He challenged the record directly, asserting that no clear evidence was presented showing donors would have withdrawn support under those conditions. The hearing also raised broader concerns about transparency and law enforcement coordination. Goldman argued that SPLC had, in fact, shared information with federal authorities in ways that undermined the prosecution's framing of deception. Supporters of the indictment maintain a different interpretation, but the exchange highlighted deep disagreement over intent, context, and legality. As tensions escalated, Goldman framed the issue as more than a legal dispute. It was about the boundaries of government power and political influence. With figures like Kash Patel also tied to the broader conversation around federal investigations, the hearing underscored how quickly legal debates in Washington can turn into ideological battlegrounds. The result was not just disagreement, but a growing spotlight on how justice is being interpreted at the highest levels.